So now we want to move into the life estates. Obviously, that's the next thing we want to talk about. And obviously, when we talk about life estates, we're talking about estates that you might own while one is alive. Okay, if you're the owner of a life estate, when you die, you have no control over what would take place with the property or happen to the property at that point, because you only own it or have control of it while you're alive. That's why they call it a life estate. Okay. Now, there are two main forms of life estates. You've got conventional life estates, which we're going to talk about those first. And then there's also some legal life estates, and we'll talk about those. But again, I do want to remind you, no one expects you to be an expert in life estates. We're just trying to get you familiar with some terms, right? Because obviously when you're dealing with real estate, you're going to be dealing with this kind of stuff. You're going to be hearing people use some of this vocabulary from time to time. And hopefully you'll have enough knowledge to at least know what they're talking about. That's all we're expecting here. Again, you're not going to be advising anybody, or shouldn't be, on how life estates work, or even if they should have a life estate. Just need to know what it is. Okay. So let's talk about these conventional life estates first. And to begin with, we start with this ordinary life estate. That's actually a really good name, I think, ordinary, because it's a pretty ordinary estate. And basically what this means is this. If you own an ordinary life estate, you own it for as long as you are alive. It means it's yours. I mean, you can do whatever you want to do with it. But only for as long as you're alive. Because once you die, you no longer have control over it. In other words, you couldn't leave in your will that you want so-and-so to take over the property or to take the property. You don't own it. You have no control over the property the moment you die. Okay? You only have control while you're alive. So, that's how these ordinary life estates work. I mean, that's pretty simple. Ordinary life estate. It's good for as long as the grantee is still alive. Once they die, then it'll go to the grantor's heirs. The grantor will be whoever you received the property from. Now, I will tell you, there are a lot of reasons to have or to put property in a life estate. A lot of people will, at some point, especially later in life, they may take property or say the house they own and put it in a life estate. There are a lot of reasons for that. We're not going to get into that. That's not something you need to be concerned about, certainly for test purposes. And you're not going to be given advice like that, right? So we're not going to get into all the reasons why you would do that. Although I will tell you, this is something I might suggest you look into, because it is pretty interesting information for sure. All right, but that's the ordinary life estate. Now this next one, the second of the two conventional life estates, is the estate per ultra V, or at least that's how we pronounce it in this part of the country. So anyway, now this is a little bit more technical, okay? But with an estate per ultra V, you have an estate that is based on the life of someone, but it's not typically the person you might think it would be. For example, I might tell Jim, Jim, I want you to be and by the way, the person that owns a life estate is often referred to as a life tenant. You hear that term used a lot. But I might say, Jim, I want you to be the life tenant of this estate per ultra V. Now, what does that mean? That means, Jim, you own this property. You own this estate. If there's any income coming in, it's all yours. But you're only going to own it as long as Mary is still alive. If Mary dies, then Jim, you're out of here. Now that's a lot different, right? Remember, with the ordinary life estate, you're dealing with an estate based on the life of the life tenant, of the person that's actually owning and using the property. But with an estate per ultra V, yes, you own it, but you only own it for as long as somebody else is alive. It's not based on how long you're alive. So that's kind of interesting. And I will just give you a real quick example of that because I think we probably need it. And these are fairly common, by the way. But, let's say you got an elderly couple and the husband is in pretty bad health. So he decides to set up this life estate in an estate per ultra V. And by doing that is, once he dies, then his entire estate will pass over to whoever he appointed to receive this life estate. And, say, for example, it might be, say, a live-in nurse, someone that's going to be living there and helping take care of his wife that obviously is still alive. And basically what they're saying here is, nurse, it's all yours. You pay the bills, any income coming in, you take care of everything because it's all yours as long as my wife is still alive. So, obviously if you own an estate like this, especially if there's dealing with money and income coming in, you might want to hang on to that for a while. But if you understand that you're only going to own this estate as long as my wife is still alive, that hopefully would give you some motivation. You better be taking good care of my wife. Because the day she dies, you out of here. Right? Now it's going to go to whoever I named to receive it at that point. But anyway, so an estate per ultra V is based on the life of someone other than the grantee. So that's kind of an interesting estate for sure. But those are your two types of conventional life estates. Now, there's also legal life estates. And let me just say this right up front before I get into these. Pretty much every state's going to have a different view on some of these things we're getting ready to talk about. When I say a different view, some states won't even recognize. This will not apply in some states. So whatever state you're in, you might want to look into this to find out, is this something that my state even allows? Okay, so just keep this in mind. But when it comes to these legal life estates, obviously the term legal might give away some of this, but these are estates that are established or created by law. Okay, there's not necessarily any agreement here. But the main gist of these types of estates is really to protect surviving family members. If one spouse dies, some of these legal life estates are put in place to protect their surviving spouse and family members and stuff like that. So let's look at what we're talking about here. One is something we call the homestead. Now, again, in states that allow this, the homestead life estate means that residence is protected from creditors. So say the husband died again with a lot of debt. Well, these creditors cannot come after the primary residence. Now, if you own multiple homes, rental properties and whatnot, y'all know that's free game. But your primary residence, creditors cannot come and take that or touch that. So that kind of protects those that you've left behind for states that recognize the homestead. Okay. But then we've also got this thing called dower and curtsy. Y'all dealing with married couples. Again, some states do not recognize this, so you want to look into it in whatever state you live in. But make sure you know what dower is, and make sure you know what curtsy is. Dower is the wife's interest in the husband's property. Curtsy is the husband's interest and the wife's property. Obviously, if one party dies, then the other party will now own all of it, right? That's what they're dealing with dower and curtsy. So if you're married, you can't just leave everything to somebody else and think you're just going to leave your spouse out of it, because they will have some legal rights to this property under the dower and curtsy, okay? But then there's this elective share. Yeah, and this kind of works the same way as the dower and curtsy, honestly. Again, not recognized in every state. But, say, again, the husband dies and for whatever reason decides to leave everything he owns to the children, and leave the wife completely out of it. So the wife receives nothing based on the husband's will. Well, obviously, based on this elective share, then the surviving spouse, the wife, can make a claim against the deceased spouse and basically get some of this property back for themselves. Okay, so obviously, when you're dealing with a married couple, when you choose to get married, you're kind of stuck. You're stuck with each other, right? It kind of makes sense. I think it makes sense anyway. I think the surviving spouse should get whatever the deceased spouse left. But anyway, again, just be familiar with those terms. That's all we're trying to get you to see there. But now we look, there's a couple of other terms, two terms that you need to be familiar with dealing with future interest in life estates. If you recall, we said, if you own a life estate, you only own it for as long as you're alive. Well, what about the future interest? What happens after that life tenant dies? Well, there's a couple terms here you need to be familiar with. One is reversion, and I think this is pretty simple. But if I gave Mary this house and I gave it to her as a life estate, then I probably included a reversionary interest, meaning, Mary, it's yours for as long as you're alive. But if you die before I die, then it will revert right back to me, because obviously Mary will have no control over what happens to it at all. So typically, the grantor, the person that's giving the estate, will have a reversionary provision, just meaning it will revert back to me if they should die before I die. All right. But then what happens if I die before the life tenant dies? Well, then that's where this remainder comes into play. Y'all remember, again, remainder is another example of a future interest. Sometimes you hear it called a remainder man. But so again, if I give this property to Mary as a life estate, I could still put in there that I'm retaining a reversionary interest in case you die before me. But I'm also going to name someone as the remainder man, someone that will have remainder interest should I die before Mary dies, right? Obviously, meaning, once Mary or whoever the life tenant is, when they die, whoever was named in the estate as the remainder man, that person will now own the property once the life tenant dies. But here's some things you need to understand about this remainder, because I suspect I know you'll get questions about it. So let's make sure we understand a couple things here. First of all, if I'm the remainder man, I know I'm the remainder man, I'm in the estate plan, but I don't like how Mary's handling this property. She's not maintaining the property, she's just letting it go down. She's not taking care of it at all. Can I step in and take any action against her or make her fix stuff, mow the grass, whatever? Absolutely not. You have no say-so and no control over that property. Y'all, and here's why, and you got to understand this. What kind of interest is remainder interest? It's future. So if you're the remainder man, that means you know you will own the property one day in the future. You do not own it today. And because you don't own it today, you have no control over that property. Y'all, so whoever the current life tenant is, y'all, they can do whatever they want to do. They can maintain it or manage it any kind of way they want to do it. And you have no control or say so over what's going on as long as the life tenant is alive. Now, once the life tenant dies, that changes everything. Now you own it. But here's what I want you to understand without me getting too graphic here. But y'all, the second the life tenant dies, y'all, when that heart quits beating, the second that happens, remainder interest disappears. You no longer, remainder interest no longer exists. But whoever had the remainder interest now owns the property in fee simple. We talked about the freehold estates, fee simple, absolute. They now own that property in fee simple. Now, why does that matter? If you see a test question, for example, and in the test question it states that so-and-so has remainder interest, or so-and-so is the remainder man, that should tell you something very, very important about what they're getting ready to ask you. That means the life tenant must still be alive, right? Because remainder interest no longer exists the moment the life tenant dies. So what they might try to ask you is something along the lines of, John Doe, which has remainder interest in such a life estate, does not like what's going on or what the life tenants do or whatever. Is there anything John Doe can do about whatever the issue is? Obviously, no. Not if you still have remainder interest. Okay? Because if you have remainder interest, that means the life tenant's still alive. The life tenant owns the property, and they have total 100% control of the property. They can do whatever they want to do or not do, right? But once remainder interest goes away, it's automatically and immediately replaced with fee simple ownership. So just keep that in mind. Again, if they ever say in the question that so-and-so's got remainder interest, then you know that means the life tenant is still alive and nobody other than the life tenant can do or say or have any control over that property. Okay? So hopefully that wasn't too difficult about life estates.